Behind every theory of administrative law, there lies a theory of the state. Current worldwide events have raised various constitutional and administrative questions. Today, we evaluate the red light, green light, and rights-based theories to consider which one of these theories is the most relevant during this time, considering events such as Brexit and the coronavirus pandemic. To discuss more on this, we have put together a panel who will share their knowledge on this matter. Without further ado, I would like to introduce Felicia, who will be discussing the red light theory, followed by Phui Mun, who will be addressing the green light theory. We're also joined today by Alexander, who will give us his opinion on the rights-based theory, and last but not least, Uthraa, who will be discussing these theories in application to recent worldwide events. Thank you all for coming to this session. Now, with the apparent human need to classify things in order to make sense of them, it is helpful to consider how current legal thoughts and practice works around two contrasting models. These two categories were coined by Harlow and Rawlings as the red light and green light theories of administrative law. Firstly, the red light theories support the views of A.D. Dicey, who believe that the rule of law's primary concern should be to stop the government interfering with individual autonomy. On the other hand, green light theories assume that the parliament and the courts should loosen the legal constraints on government discretion, enabling government to curb individual autonomy in order to promote society's collective well-being. Now, it is important to note that there is a distinct difference between the theories previously mentioned and the rights-based theory. While the idea of the two is such of the manner which the courts interfere with a particular body's decision, the rights-based theory is a principle based on what infringements would the court consider when invalidating the decision. These ideas toe a fine line between public policy and the invasion of personal private rights. However, before we go into that, for more on the red light theory, its roles and criticisms, here is Felicia.
Administrative law is the tool which prevents the powerful engines of authority from running amok. Harold Laski described constitutional law as where the government was an expression of the society it operated, designed to serve as rampart. He introduced a more politically conservative view known as the red light theory. The red light theory believes the powers of the executive should be subject to checks and balances from Parliament and the courts. At their core, such theories posit that the primary function of administrative law is to ensure that the exercise of power entrusted by sovereign legislature are conferred on them reasonably in good faith and doesn't exceed its limits. The theory views executive action should be checked by the courts in cases interfering with individual rights and interests, or in other words, ultra vires. Before going into depth, we must first look at the core elements and beliefs of this theory. A famous red light theorist, Dicey, expressed three elements of the rule of law. Firstly, no person can be lawfully punished for conduct that is not in breach of the law. Secondly, no man is above the law regardless of rank and is subject to ordinary law of the land. Finally, principles of the Constitution, such as rights to each citizen's liberty, are upheld by judicial decisions in cases before the courts. To reiterate, the theory looks at the model of a balanced constitution and favors using judicial controls such as judicial review to protect individuals' rights, such as in R versus Secretary of State for the Home Department. A claim brought by judicial review declared the Sexual Offences Act 2003 incompatible with Article 8 of the European Conventions of Human Rights, the right to respect for private and family life. This case is exemplary that between interference with citizens' rights or the importance of parliamentary sovereignty, rights will prevail. The application of the red light theory have tended to allow judicial review only in cases regarding a public law element. Lord Lloyd stated when determining rights to judicial review, courts mustn't only use the source of power test, but consider the nature of the power on whether the body exercised public law functions or public law consequence resulted from the decision. This was followed by Lord Justice Dyson stating that the sufficient public element was necessary to ensure good administrative practice in matters with significant public importance, protecting common law rights and respecting public policy. Lord Diplock classified four grounds of judicial review of an administrative action, namely illegality, irrationality, procedural impropriety, and proportionality of an executive decision. As the state regulates multiple things simultaneously, there is a high possibility for power to be abused or misused. There are multiple advantages to this theory. Firstly, the protection of human rights and the Constitution, where the executive decisions interfered in the interests of society and individuals. Evidence of this is found in ATM Treasury versus Ahmed, where fundamental rights may not be overridden by general words of a statute unless by express language with necessary implication. Lord Lloyd also expressed that the government's intentions may be judged by their deeds as well as their words. In this case, the minister had exercised discretionary power granted to him by Parliament to the point which was so unreasonable, no reasonable minister would have done the same. Secondly, accountability is achieved by the government, and other members of power are held responsible for their actions. Lord Justice Laws expressed that courts can be more interventionist where individual rights are stated in terms that are unqualified and where the decision under challenge has been taken by an unelected official or minister who is also answerable to a legislature. Thirdly, the element of transparency in executive action is taken more seriously by officials because their decisions may be scrutinized by the courts, such as in M versus Home Office, where the House of Lords held that the injunctive relief against a minister or officer of the Crown is available. However, there are criticisms faced by this theory. It has been criticized that there is a breach of the separation of powers by way of the judiciary encroaching on the duties of the executive, restricting the government. As mentioned by Lord Justice May, the courts must not unconsciously stray from its purpose of reviewing the decision-making process into the forbidden territory of evaluating the merits of the decision. Furthermore, judicial decisions may infringe upon matters of policy for the simple reason that judges may have conflicting opinions with the executive about what would be disadvantageous to the government and the public. Lords Keith and Mustill dissenting judgments conveyed that the decision in ex parte fire brigades union was quite simply not justiciable. It was of a political and administrative character quite unsuitable to be the subject of review by a court of law. Finally, the argument of majoritarianism. In cases where a balance must be struck between the breach of an individual's rights and a broader public interest, this will in the long term undermine parliamentary sovereignty and constitutionalism. Lord Wolfe stated that if contempt is found by the government's conduct, the Parliament should determine the consequence of the finding. When speaking on how the red light theory has developed, Don Oliver expressed that judicial review has moved to protecting the rights of individuals and controls of the power rather than by right. He implied that judicial review was remedial to containing administrative action within legality, and so is a common law principle rather than parliament sovereignty. In conclusion, the red light theory believes that for justice to be achieved, there is a need for administrative law to keep the powers exercised by the executive and administrative authorities within their jurisdiction to protect the rights and interests of the society it represents. This should be performed by the courts to ensure powers are practiced reasonably and intra vires to avoid absolutism.
Thank you very much, Felicia. Now it is evident that the red light theory can be seen during the case of Brexit. Perhaps Uthraa, can you further discuss this?
Thank you, Ashraf. A recent worldwide event, which is exemplary of the red light theory, is Britain's exit from the European Union. Recently, there has been increased talk about whether the judiciary has overstepped their powers in the recent case of R on the application of Miller and the Prime Minister. The Supreme Court held that the prorogation of Parliament last year by Prime Minister Boris Johnson was unlawful. The decision goes uncomfortably against the High Court of Justice in London and the Court of Session in Scotland that respectively decided that prorogation was a non-justiciable matter. Therefore, amongst the courts themselves, we see that there is a divide in opinion on the justiciability of the matter. To summarize, the judgment follows this train of thought. The people decided to leave the EU in the referendum. The House of Commons is democratically elected and therefore represents the people. For this reason, Parliament should be able to carry out their function, and the act of proroguing Parliament would counter that. Now, legal opinion on this case are divided as well. In one corner, some are of the opinion that the Supreme Court protected the rights of the sovereign people by putting the executive under scrutiny. As stated by Sir Stephen Sedley, the judgment has relit one of the lamps of the United Kingdom's constitution, that nobody, not even the Crown's ministers, are above the law. In contrast, there is strong legal opinion that this was a bad decision. Before I elaborate further, let's go back to a fundamental issue of the red light theory as highlighted by Felicia. Now, at what point do courts overstep their boundaries and violate the separation of powers? And precisely, this is the issue exemplified by this case. Brian Harris states that the Supreme Court was trying to speak on the behalf of Parliament, which it had no power to do so. He goes on to reason that since the prorogation was not with immediate effect, the Parliament, choosing not to resist, alludes to their acceptance of the prorogation. Looking back at constitutional law, this seems to encroach on the very principle of the separation of powers. In addition, another view is Martin Lawlin, who reasons that the Supreme Court has effectively extended its supervision powers to the power of prorogation under the guise of parliamentary sovereignty by claiming that Parliament will be unable to carry out its function when prorogued for an extended time. In fact, Professor John Finnis affirms with the radical suggestion that the judgment is a plain usurpation of constitution-making responsibility and authority. Now, this issue can be argued both ways, but we won't get into that today. To summarize, in my opinion, certain situations call for a red light approach so that courts may defend the Constitution against unaccountable political power. But courts should be cautious and not rush to intervene until, as Lolland put it, political practices embedded within the British parliamentary system are unable to do their work.
Now, going to the other side of the spectrum of the green light theory, we have Phui Mun.
Thank you. Essentially, green light theorists favor an administrative state and view administrative law as means of political progress. This theory is a metaphor summarizing the two main ways of interpreting the relationship between law and government and the task of judges in judicial reviews. The basis of Harlow and Rollins' categorization is not confined exclusively to the court's role in judicial review. Rather, it can be expressed in general principles related to the importance and the goal of administration, which is to protect and facilitate individual liberty. The green light theory's roots can be traced back to the collectivism expressed by Davies and the belief that it is the purpose of a collectivist state to provide public services. The green light theory is simply the belief that administrative law should facilitate rather than control state operations. Harlow argues that green light theorists all have one common argument, and that is to downsize courts' influence as they view the legalistic values of courts an obstacle to progress, and that their exercise of power is unrepresentative and undemocratic. While green light theorists also acknowledge the cruciality of the rule of law and judicial review, more emphasis is placed on non-judicial remedies, political processes, and consultative decision-making. The reasoning behind such belief is backed up by the shortcomings of courts in administration. Hutchinson argues that first, courts rely on an adversarial process. Second, they curtail potentially relevant information. Third, do not consider the aftermath of a decision. Fourth, they limit the number of individuals. Fifth, collective interests are not prioritized. And lastly, sixth, they embrace the cast of negative bind. In short, Hutchinson believes that courts are incoherent and ineffective in fulfilling its purpose. However, as of the 21st century, Uthraa contends that judges have become increasingly aware of growing democratic legitimacy of government credentials and the limitation of adjudication processes in determining complex public interest issues. The question then becomes, what do green light theorists suggest in overcoming such shortcomings? In answering that, Griffith and Steele believe that the influence of a parent over a child may be greater than the power of a prison guard over a convict. In other words, this metaphor expresses that green light controls, which are direct and internal, may actually be more effective. Administrative law controls includes the legislative and secondly, an internal hierarchical supervisory control. These controls can be illustrated by the trickle-down affair involving the Minister of Agriculture's resignation and acceptance of his responsibility towards Parliament for the mistakes and inefficiencies of his department. This illustrates the doctrine of individual ministerial responsibility, giving priority to mechanisms involving ministers in supervising activities rather than their responsibility to Parliament. Griffith, however, acknowledges that the doctrine of ministerial responsibility doesn't necessarily uphold accountability effectively, though the remedies should still be political. On a similar note, Hutchinson believes that the notion that courts are crucial in developing a better organizational ethic and democratic practices should be disregarded. This suggests that to disregard the red light model of law, there should be other mechanisms apart from the traditional model of government. In highlighting the need of such mechanisms, supplementing the traditional model of government in assuring effective administration function, Griffith's 1978 Charlie lecture titled The Political Constitution argues that there should be rules and machineries that operate to ensure public authorities are not in excess of their legal powers. Despite the need for such mechanisms, he strongly opposes the formation of a Bill of Rights which would judicially impose enforceable limits on the legislature on the basis that it would not cure political claims, instead convert them into disagreements about the true interpretation of legal vocabularies in the Bill of Rights, ultimately leaving this decision to the judiciary. Additionally, he contends that these mechanisms include an open government, access to information, powerful and a free press, a strengthened parliament, and decentralization through local governments. Essentially, in a society like ours, such decisions should be made by politicians, those who are removable. Hence, reforms should not fixate on a Bill of Rights restricting Parliament's capabilities to legislate, instead on mechanisms intensifying Parliament's potential to hold those exercising political powers accountable. As Griffith acknowledges, measures of political accountability, for instance, ministerial responsibility, do not operate as effectively as wished. Therefore, he suggests that there should be other mechanisms supplementing the traditional model of government. In answering that, Tonkin also suggests parliamentary ombudsman, and lastly contends that the role of select committees as a mechanism to supervise departments by attaching user and clearly impartial investigatory committees to handle severe complaints against these departments. The select committee aims to prevent these departments from repeating the same mistakes, simultaneously remedying individual grievances and improving administration in the long run. Despite these green light mechanisms, because the democratic process is the constitution, this implies that green light mechanisms often work imperceptibly and primarily within Parliament and the executive. Hence, even where observed, it will seem unmethodical compared to judicial review. However, the perception of the effectiveness of judicial review isn't the crux of this discussion, as this theory is aligned with the belief that constitution making is a continuous political process, encouraging us to plot the constitution as it was made, amended, and sustained. Supporting this motion, Bellamy uses the analogy of rebuilding the ship at sea to illustrate his point on using existing political procedures of ordinary politics whilst simultaneously reviewing them. To conclude, it is worthy to note that Griffith's political constitution was repackaged as an opposition of legal constitution, causing an adversarial relationship between legal and political constitution, motivating an inclination for political constitutionalism to appear as a zero-sum game, in which Kavanaugh beliefs cast administrative law in extreme opposites, creating a minimalized view, distorting our comprehension of the British Constitution. Lastly, the concept of the red and green light theory are evidently not exclusive from this criticism, as treating judicial review as traffic lights disables us from comprehensively understanding British public law. Thank you.
Now, thank you for your input. Yet, Howler and Walling suggest that we can identify a third theoretical position where both theories are acknowledged, and this is called the amber light theory. Amber light theories tend towards the view that law should control the exercise of executive discretion when that discretion has an impact on individuals' constitutional rights. Despite this attempt at unification, it remains useful to continue to think of the process in terms of two models. With the two theories being addressed, we now move on to Alex to share his views on the rights-based theory.
Thank you for the lovely introduction. The rights-based theory is founded on the belief that there are basic rights and liberty which must prevail and be preserved irrespective of the preferences or will of the democratic majority. The term rights-based judicial review, however, may seem to be a rather fickle matter. Rights on the surface being such a general term is skewed today by political probing, provoked by endless activism. This, however, is no blatant criticism of the term, but our seeming faith in the healing power of rights can only be strengthened when we witness the dreadful persistence of man's inhumanity to man. Rights are that which are quite different to duties, or somewhat separate to that of morality. They are the foundation of a liberal society, and their principles must be protected. However, common law theorists such as Thomas More provide no more than a brief description of the nature of rights and their function within judicial review, and this function is still a genuinely academic and extrajudicial phenomenon. Despite such, in legitimacy, rights, and judicial review, More explains that rights can be understood as the rights of individuals, and it is the core of right towards man which exists, and that these rights cannot be denied for a potentially critical loss of what constitutes being human. In short, there exists a higher order of law, following that the primary purpose of the court in reviewing an act of a public body is to perform rights-based justice, and coming all together that judicial review is necessary in order to enforce the higher body of law grounded in rights. It may be said that it's the individual who must recognize these rights, and in turn the court to collaborate with the individual to enforce this. For example, the articles consolidated in the Human Rights Act, and by extension the ECHR, are a subset under the umbrella term of rights-based judicial review. Although some may argue that the HIA suffices and has a pragmatic presence in practice, it follows that the articles are not an exhaustive statement of fundamental rights under our system. The higher order of law, as mentioned earlier, is one of the most important aspects here. It dictates that a set of constitutional values transcend the ordinary, more transient and particular rules enacted by legislature. The court acts as a primary guard of society's fundamental values and rights, as the protector of such rights, and arbiter, with Sir John Mill later explaining how the democratic credentials of an elected government cannot justify its enjoyment of the right to abolish fundamental freedoms, and these principles would form the basis of rights which must be safeguarded by the courts. In Secretary of State for the Home Department, ex-parte Henry Fevre, the House of Lords had to consider whether an internal note in the department file was legally effective in withdrawing income support for an asylum seeker in light of the fact that there is no communication of such withdrawal. It must be noted that a withdrawal of income support was only communicated to the benefit agency, and not as it should have been, to the actual applicant. The principles of legality were heavily drawn upon in this case. Such explains in the absence of clear words to the contrary, one must presume that the legislation was intended to be subject to the basic rights of the individual. Here the Lords held that in favour of the applicant, due to an astonishingly unjust process which fell short of the accepted standards of administrative conduct, infringing on the rights of the applicant. Lord Stern's words here encapsulate the need for judicial review, explaining how this case provides a peep into contemporary standards of public administration. Transparency is not hallmark. It is not an encouraging picture. Now, Lord Stern's speech, so echoing the background, is necessary to now engage in the doctrine behind the court's interference with democratically elected government. In order to answer this, we must refer again to the supremacy of Parliament. With such a principle, direction of abuse of power is very much possible. In the case of Secretary of State for the Home Department, ex parte benefits can be used to illustrate the necessity for checks and balances. Here on appeal to the House of Lords, the decision of the Home Secretary was quashed as he considered immaterial factors, disregarding the rehabilitation of the inmates during the sentences and their actual right for liberty. However, the justification for judicial review is somewhat muddled by what Poole describes as second-order matters, which derives its meaning from judicial separation between positive and negative rights. Negative rights stem directly from fundamental moral principles, whose aim is to protect the individual autonomy by restraining unwelcome governmental activity. Developed by the courts, these are a minimum set of standards for the relationship between the ruler and the ruled, and the right to be left alone. Positive rights, on the other hand, do not have constitutional status. They are ambitious or aspirational benefits which may come about from democratic choices, carried out by the executive. The thoughts today can be seen to have taken a rather prima facie stance. As Poole discusses, they look not directly to questions of moral fundamentals, but rather to issues of competence and authority, closely resembling that of positive rights. Expanding further on positive rights, in short, these are matters relating to whether the courts have the prerequisite authority to adjudicate governmental policy. For example, can a court meddle in a decision based on the decision of an expertise body? In the case of Ex parte B, the court described how they were not in that position, as they lacked the specific expertise needed with regard to the refusal of leukemia treatment and the right to life in this case. Here, in spite of the laudable goal of protection of rights in life, the court was unable to adjudicate due to circumstances such as the authority's budget, which was not within the court's realm of adjudication. Now, with my previous statements in mind, it may be fair to say that rights-based judicial review is an extremely complex topic. The protection of individual rights is purely the tip of the iceberg, and application to real warfare is challenging. It is a paradox in that, in order to protect an individual's rights, there is a necessity to ascertain what those rights actually are. The rights are, as my opening statement suggested, inherently subjective, open to endless discussion. So now there is no end in sight when humans ponder upon humanity. As Lord Bingham explains, the law must be accessible and, insofar as possible, intelligible, clear, and predictable. In an ideal world, where definition of rights are clear-cut and agreed by a majority, this principle would triumph over all. However, agreement is very hard to find today. Thank you.
Thank you, Alex, for that wonderful explanation. Now, with all that being said, let's discuss which theory we consider to be the most relevant theory based on what's happening around us at this moment in time. Now, we are obviously speaking about the coronavirus, which has taken the lives of over 3 million people. Article 15 of the ECHR allows countries to declare a state of emergency in times of war or other public emergency threatening the life of the nation. This reflects very much the green light theory. However, states cannot just do whatever they like to respond to the crisis, reminiscent to the red light theory. These times have tested countries' commitment to the rule of law. The rule of law, which has been described as the crucial building block for any society to be able to prosper. Without the rule of law, a nation's prosperity declines, human rights are abandoned, and social order eventually breaks down. In times like these, where the interest of the public at large has to outweigh individual freedom, this so-called balancing act, where we want to protect the individual freedoms, sometimes has to be held back for the interest of the public. Yet, there are ways states can abuse this moment in time, and this is what we have been seeing around the world. To discuss more on this and what's happening in the United Kingdom, I would like to invite Uthraa.
Thank you, Ashraf. Now, looking at the red light, green light, and rights-based theory, I'm sure a question in our viewers' mind is which theory applies right now to the current COVID-19 pandemic. As Ashraf mentioned, the green light theory. Let's look at it in depth. The UK has seen its fair share of the pandemic in its motherland. In response, the government has introduced what politicians have described as emergency powers, but has not yet declared a state of emergency. In fact, the government convinced Parliament to pass a lengthy legislation, the Coronavirus Act 2020, allowing extra powers in less than a week. The Coronavirus Act 2020 introduces temporary measures designed to mitigate the effects of the pandemic on the workforce and health services. Most central to our concern is that it grants certain officials, such as police, immigration officers, and public health officials, powers to detain and screen persons with or suspected to have COVID-19. In addition to additional powers, the UK government has also enacted a health protection regulation to impose a nationwide lockdown. Now, this means that there are several restrictions on liberty and freedom of movement of persons. The centerpiece of the regulations is found at Regulation 6 of the Health Protection Regulations 2020, a requirement that provides that during the emergency period, no persons shall leave their home until further notice other than for limited purposes. Those who breach that obligation are subject to a criminal offence, punishable with a fine. Now, there are three concerns that we will discuss today. Firstly, there is a blurring of the boundaries between what the law says I must do and what the government says I ought to do. Now, the difficulty is that what is being represented as rules are not rules but as a guidance. For example, the actual rule in Regulation 6, subsection 2b, states that a person may leave the house to take exercise, but it does not include a 2-meter limit. Essentially, if a provision is important, it should be included in the rules. In support of this, there has been a good deal of discussion by scholars, such as Tom Hickman, about the lawfulness of the regulations. In fact, Lord David Anderson of Ipswich concluded that the impact on personal liberty in Regulation 6 goes right up to the limit of what is permitted under the Parent Statute, and even arguably beyond. However, Hickman and Lord Anderson point out that in times of crises, courts may adapt rules of statutory interpretation in a way that confers the widest powers on the government, but also acknowledge that it is preferable for the measures to be placed on a firmer legislative footing. Moving on, the second issue is in regards to Section 3 of the Health Protection Regulations 2020. The section provides discretionary power to the government, which may pose an issue in terms of the government acting ultra vires. Other than the government possibly acting beyond their powers, the third issue is in regards to the enforcement of the regulation. Now, Lord Sumption states that there are concerns about how the UK police force actions are being overdone. For example, the recent incident of the Derbyshire police dyeing the Blue Lagoon pond black to prevent people from swimming in it. Another incident, as explained by Lord Sumption, is the police trying to stop people from doing things like travelling to exercise in the open country, which are not contrary to the regulations, but simply because ministers have said that they would prefer that people not do that. Now, this brings us back to a key issue with the green light theory. The government and its subordinates may act ultra vires or in an excessive manner. However, we do acknowledge that in times of crises, such as the COVID-19 pandemic, the government is expected to take immediate measures to ensure the safety of the public. On a positive note, New Zealand's government has responded in a manner that supports the utopian ambition of the green light theory. The New Zealand government's Go Hard, Go Early response has garnered widespread praise. In March, Prime Minister Jacinda Ardern immediately announced publicly the 4-stage COVID crisis response alert. There were questions surrounding the legality of the lockdown, to which Justice Peters in A versus Ardern and B versus Ardern held in both cases that the conditions of the lockdown did not amount to detention and that the lockdown was in any event lawful. Although we must consider that New Zealand is a smaller population which contributed to the success of the government, here's what the United Kingdom can learn from New Zealand. Firstly, governments should fully respect the right to access to information and only restrict them as international standards permit. Furthermore, the government should avoid sweeping and overly broad restrictions on movements and personal liberty and only move towards mandatory restrictions when scientifically warranted and when mechanisms for support of those affected can be ensured. To sum it up, the immediate cooperation between the executive and the judiciary, clear regulations and open announcements from New Zealand's Prime Minister and the government exemplifies how a government ought to act in a state of emergency. In conclusion, this pandemic has taken the world by surprise and governments are doing their best in mitigating the situation. The issues raised in response to the UK government's actions should not be forgotten, but taken inspiration from to mitigate further emergencies better.
Thank you, Uthraa. Now, we have seen something like this happen in the past. It's just a matter of will we learn from it. Looking back in history, during the Second World War, the United Kingdom governments implemented drastic measures to limit the freedom of those it considered to be at risk to its war efforts. For example, the case of Liversidge and Anderson, it demonstrates how easy it is for even the most experienced of judges to be blindsided from the rule of law during times of emergency. Here, the government passed a regulation that gave a minister discretionary power to detain someone if she was satisfied that such a person's detention was necessary for the defense of the realm. But what about the rights of an innocent person, you might ask? In this decision, a majority of the judges found that the minister had a wide discretion which wasn't challengeable in the court. In the crisis, instead of subjecting a politician to review of the rule of law, they tried to give a politician absolute power to detain someone. But the true and lasting lesson of the case was from the dissenting judge, Lord Atkin. In a speech that we should actually learn from, he stated that amid the clash of arms, the laws are not silent. They may be changed, but they speak the same language during the times of peace. In ordinary times, such things may be considered unconstitutional. Crises are not ordinary times. So, with all that being said, the concern is that even though special powers may be taken by the state, there has to be certain requirements. These requirements may be that the discretionary power is given to a time limit, or that there are clear ways to review and monitor the use of these powers. Therefore, in this moment where challenging and difficult times calls for taking steps we could not consider in ordinary times, the phrase "desperate times calls for desperate measures" should not be taken literally, as one should not go beyond what is necessary. Considering the situation in the United Kingdom, it can be concluded that the green light theory is the most relevant theory. However, with that being said, even in the midst of the most serious of crises, there is no need to abandon the rule of law. Society is not benefited in the long run by removing the foundations upon which it is built. Thank you very much.